Good morning. Good morning. This is Bruce Bowling, and the program is Jamaica Live. We're on Bridge 99, broadcasting from here in Kingston. But at 1 o'clock, we're going to be linking with Irish Jam in New York so that we can be heard in that area where so many Jamaicans reside. So I want to thank you for joining me today. Trial by jury has been a feature of the judicial process from time immemorial, especially in common law jurisdictions such as we have in Jamaica and indeed throughout the Commonwealth. It all goes back to the Magna Carta. Some of you may have heard of that. The Magna Carta was promulgated in England more than 800 years ago, in the year 1215 to be precise. And the Magna Carta enshrined two pillars of democracy. One was representative government, that is the right to choose your government through elections. And the second was trial by jury. That means that you are judged by your peers, your equals, your fellow men, ordinary people like you. The concept of trial by jury seems to have been based on a mistrust of officialdom. There seems to have been a fear that a representative of the state, and the judge is a representative of the state. But there seems to have been a fear that a representative of the state would arrive at a verdict to protect the state, not necessarily being fair and just to the person whose life or liberty may be on the line. Trial by jury is commonplace in Jamaica. It is used in cases involving serious offenses like murder, manslaughter, rape, carnal abuse, robbery, arson, and treason, which is not something that has occurred very often. It is also used in some civil cases, not criminal, some civil cases, and it is used as well in some coroner's inquest. I was summoned for jury service back in 2016. It was for a coroner's inquest. And one of my lawyers told me that she could ask the judge to excuse me from jury service. And I said no. Many persons who are called to serve as jurors provide all sorts of reasons why they should be excused. Some of those reasons are quite legitimate. They have to go to work. They have a bedridden mother or father that they have to take care of. Or they're waiting for a visa appointment to go and look for the children in America, so they're not likely to be here. But many of them are just unwilling to serve, and they will try every conceivable means to avoid sitting on a jury. I took the position as a former prime minister, I ought to set an example. So I went. And I ended up being selected by the other jurors as the foreman of the jury. That case had to do with a young lady who was found to have committed suicide at the Horizon Remand Center. Some of you may remember the case. Her name was Vanessa Wint. That inquest was held over 17 sittings over a period of 4.5 months. And I, along with the other jurors, had to be there every time. It was an interesting experience for me because I was seeing at first hand how a jury operates in real time. Not just up front and close, but right in the acky. That jury was made up of ordinary people. A couple of housewives, I'm trying to remember, a couple of housewives, a nurse, a retired civil servant, a maintenance worker, and I think one or two of them were unemployed. But I was very impressed with how they dealt with the case. They paid close attention to the evidence that was being given. They would pass notes to me about questions they wanted to be posed to the witnesses. After all the evidence was presented and we retired to consider the verdict, they raised very important questions, and on their instructions, I communicated with the coroner to get clarification and further guidance. And if any of those jurors happen to be listening, be assured that you were superb, and I was extremely proud of you. One of the problems with the jury system is that jurors are not properly compensated for the time they have to spend when they serve on a jury. A juror gets an allowance to cover the cost of transportation. We were provided with tea and coffee and lunch. Ordinary Jamaican lunch, which I enjoyed, fried chicken and stew peas and rice and cow foot. Real good Jamaican stuff. But the allowance that you get is pitiful. $2,000 for each day that you have to attend the court or the court, even in the case of a coroner's inquest, that's a court. So if a plumber or electrician who would probably earn $10 or $15 or maybe even $20,000 for the day, if he's called to sit on a jury, he has to give up that income. That income that he needs to look after his children, and in return the government gives him $2,000. What does he say to his children when 1 week when he's serving on a jury, he can't find the bus fare and the lunch money to send them to school? And if you happen to be appointed to a government board, one of these public corporations, which is voluntary service, you're not forced to accept it, and there's no penalty if you don't. You get an allowance of $10,000, $15,000 maybe. Some of the big boards, you may get as much as $20,000 when you attend a board meeting. But we pay our jurors who are giving not voluntary service. When you receive a summons to serve on a jury, and unless you are excused from serving, you can be fined for not turning up. We pay them $2,000. Come on. That can't be right. We must can do better than that. Now let's talk about how the jury system works. A jury consists of 12 persons where a person is charged with murder or treason. And in all other cases, the jury consists of 7 persons. In cases of capital murder or treason, all 12 jurors must agree whether to find the person guilty or not guilty. In the other murder cases and in the other jury trials, at least 9 of the 12 must agree guilty or not guilty. And if it is a jury of 7, at least 5 of them must agree before a verdict can be delivered. There are some serious offenses that are not allowed to be tried by jurors. gun court cases, for example. That was carved out of the jury trial system. And that carve-out is significant. I'm going to come back to that later. Now, the list of jurors is drawn from the voters list, but only persons between the ages of 18 and 70 can be on the list. So I'm over 70 now. Back in 2016, I wasn't. So I could no longer serve on a jury because I'm over 70. So it is between 18 and 70. There are certain categories of persons who are exempted. Elected officials, like MPs and councillors, certain appointed officials, senators. Judges can't sit on juries. Civil servants can't sit on juries. Medical personnel and teachers are also exempted, I suspect, because you don't want to disrupt the health services or the functioning of the schools. And there are a few other categories of exemptions. I don't need to go through all of them. Persons who are charged with an offense to which a jury trial would be applicable can choose to be tried by a judge alone or by a panel of judges, which is called a full court. So if you're charged with an offense and that is an offense to which a jury trial is applicable, you as the person who has been charged can decide, no, I prefer to be tried by a judge or a panel of judges. Persons who are accused in a jury trial are also entitled to object to their lawyers normally. They are entitled to object to persons who have been selected to sit on the jury, but you can't object to more than 4 persons. You can't object to all, But you can, I think, last time I looked at the law, you can object to up to 4 persons. Now, there are many persons, especially defense lawyers, who hold that trial by jury is a right, something almost sacrosanct. I'm not sure about that, and I will want to explore that with, we're going to be talking with 1 or 2 defense lawyers in the program. But I'm not sure about that because I don't think there is any provision in the Constitution which guarantees the right to trial by jury. It may have come to be regarded as a right by convention and by practice. It could hardly be a guaranteed right, since persons facing charges in the gun court are not entitled to a jury trial. They are tried by a judge. What makes this point particularly germane at this time is the recent call by the Chief Justice, Mr. Justice Brian Sykes, for the abolition of jury trials. What triggered his comments is the difficulty being experienced now in assembling jurors to sit on cases during the COVID pandemic. In a situation like that, all jurors would have to be tested, and they would have to test negative. Many potential jurors would perhaps ask to be excused because of the fear that they may have of picking up the virus if they have to serve on a jury panel. And especially so if these are persons who have underlying health conditions, what they call comorbidities. And logically, you can't be asking people to avoid gatherings as much as possible. And at the same time, you are forcing them to expose themselves to gatherings by sitting on a jury. But Mr. Justice Sykes' view on the usefulness of the jury system seems to go beyond just COVID. He says that there is nothing to suggest that a jury trial provides a better quality of justice than trial by a judge or a panel of judges. I want to come back to this whole the foundational principle behind trial by jury. it rests on two legs. And these are important. One, it is based on the idea that people should be accountable to each other and not to the state or judges appointed by the state, because states sometimes are inclined to be tyrannical and unjust. And secondly, the other leg on which this concept of trial by jury rests is that a jury is made up of ordinary persons, just like the person being tried, and is more likely to arrive at decisions that reflect the general accepted values of the society. I have some difficulty with that one, this last one. It is one of the arguments that has been put forward to support dispensing with the Privy Council and making the Caribbean Court of Justice our final court of appeal. And I support that. I support we had that discussion on this program recently about it, and it's clear that I think the time has come for us to do away with the Privy Council. But this argument that is sometimes used to support that idea, that our own judges in the region have a better understanding of our values and our norms and our culture. I believe that justice is justice. Justice is universal. Justice is indivisible. I have very grave misgivings about nationalizing justice. You have a British justice, and you have Chinese justice, and you have American justice, and you have Afghanistan justice, and you have Jamaican justice. And there may be differences from one justice to the next. You know, there are some countries where female genital mutilation, you know what that is? Cutting off a portion of the female genitals shortly after birth, when that is a little baby girl. But they remove a portion of that little girl's genitals. They say, in order to reduce her sexual urge when she grows up. And they say that is part of their culture. That is recognized by their justice system. That is part of the accepted value of their societies. I just believe that is repugnant and reprehensible. It is wicked. And I don't want them to tell me that is so they live. That is their culture or their values. It is wicked. In some countries, for example, a woman found guilty of adultery can be sentenced to death by stoning. Good God. What kind of justice is that? I don't care what your culture and what your values say, that is just wicked. Now, during a trial, the interpretation of the law and how it must apply to the case is determined solely by the judge. He or she is trained in the law, and he or she will instruct the jury as to what the law says and doesn't say. You know, a judge may say to a jury, if you arrive at the conclusion that the accused did this or that thing, then you should find him guilty. Or the judge might say, the question as to whether the accused should be found guilty rests on the evidence of John Doe and Mary Jane. If you believe their evidence, then you must find the accused guilty. If you're not satisfied that they were being truthful in their testimony and you cannot come to a conclusion that what they said happened did in fact happen, then you should find the accused not guilty. That's the kind of direction that a judge would give a jury. But it is the jury's job, having listened to the evidence, to come to their own opinion as to whether the person is guilty or not guilty. One of the criticisms of the jury system is that jurors are ordinary people like you and me. They're not trained in the law, and therefore they're not likely to be competent to make a determination about guilt or innocence. Well, as I just pointed out, they don't have to concern themselves with legal technicalities. The judge takes care of that. Their job is fact-finding, finding the facts. Did the boy shoot the woman? Because if him shoot the woman and the woman not trouble him, then him guilty. And that's the verdict that we're going to deliver. Some people have expressed concern about the integrity of jurors. And how can you guarantee that integrity? Well, in life, there are very few things that you can guarantee. And what happens, for example, this is the argument. What happens if a Don with a whole heap of money sends an emissary to go check out each juror with a big brown bag full of a whole heap of sharers? One juror may run them. One juror may say, well, you want to get me in trouble? But what if there is a couple of jurors, even one? Because remember, in a capital murder case, you need only one juror to say, no, I don't believe him guilty. And that jury cannot return a guilty verdict. It is a reasonable concern. Those who defend the jury system will say that there is no evidence that anything like this is happening or has happened. But because there is no evidence, it doesn't mean that it doesn't happen. Because who would that evidence come from? The Don man? Or the emissary? Or the juror who collected the bag full of sharers? None of them going to talk. Sometimes when a jury delivers a not guilty verdict, you hear the comment, them buy out the jury, although they don't present no evidence. You don't stand much, if any, chance of getting a judge to accept a brown paper bag full of sharers. He or she would probably call the police to lock you up, and you would end up spending a whole heap of Christmas in prison. Although you will sometimes hear comments, but no credible evidence, after a judge hands down a verdict like, then buy out the judge. We can't treat an argument lightly when it comes from no less a person than the Chief Justice of Jamaica. So that's what we are delving into today. Should Jamaica abolish trials by a jury and have all cases tried by a judge or a panel of judges? That's the question. In our discussion today, as always, all views will contend. On this program, we provide information to you through discussion and argument, and we leave it to you to come to your own opinion. And hopefully, an opinion that would have benefited in whatever direction by the discussions that we conduct. Today, because this issue is so topical, and this issue is one that could affect any of us, because any of us can be charged. We don't normally invite calls, but today we're going to make a difference. Some people have been complaining that, we should spend some time and allow people to call in when we're having these discussions. And it's something that we're going to give some consideration to. But today in particular, we're going to take your calls, and I'm going to give you the numbers in a little while. 876-630-3327. 630-3327, 630-0635, 633-4692, 633-4718, and I'm going to repeat them a little later. So if you have an interest in this issue, call us and talk to us about it, because I know that there are people who have strong views about it. Should we do away with trial by jury? Let me hear your views when we come. The Chief Justice of Jamaica recently called for us to do away with trial by jury. What do you think? Today you can call us and share your views with us. Give you the numbers again, 630-3327, 630-0635, 633-4692, and 633-4718. I'm very pleased now to welcome to the program to help us understand the issues involved in on this very important question. A very prominent attorney who I know does a lot of work at the criminal bar. I'm talking about Mr. Christopher Townsend. Mr. Townsend?
Hi, good morning, Mr. Golding. How are you? It's afternoon now.
I'm very well, very well. Thank you for joining us.
Thank you for having me on your program.
Give us the benefit of your wisdom and your experience. The Chief Justice has made a very strident call.
Yes.
What do you say?
He has made a very good point in that the legislature seems to be going in the direction of having non-jury trials. He highlighted the fact that quite a number of offenses that were tried by jury is no longer tried by juries. For example, he cited the what is it again? Lord, it's let me know.
Well, I know that when the gun court was established, that was carved out, no?
Right. But the human trafficking, that is one of the more recent ones that was tried by jury, because I did one in particular where we tried it by jury, we got a hung jury, and we had a retrial recently by judge alone. Same case, just at different time, legislation changed. So that one was more obvious for me in terms of the different effects of one trial by jury, two trial by judge alone. But so we seem to be going there slowly. What the Chief Justice is saying, really, from my perspective, is that we need to get there sooner.
But should we be going there any at all?
I do believe that it is inevitable that we will be getting there any at all. My colleagues, you do have some of my colleagues who are of the view that in our present state, in our present development of our jurisprudence, it is perhaps not safe, and jury trials are in fact better. The argument that is made is because of our recruitment mechanisms for our judges. As you would perhaps know, Bert Samuels did a paper on it, that 95% of our judges come from the prosecution bar, the private prosecution bar. Sorry, the prosecution bar, that is the DPP's office.
Yes.
And so, if you are the sum total of your experiences, it means then that you are primarily a prosecutor, and you will have the prosecutorial mind when it is that you are sent to the bench.
I'm going to ask you an uncomfortable question. From your experience in the court,
yes,
those judges who originated in the prosecutorial arm of government, do they reflect a bias that may be rooted, maybe unwittingly, in their orientation as prosecutors?
Without a doubt, they can't escape it. If you are trained for one thing, then when you go on the bench, there is nothing else to inform you. You have nothing else to draw on.
But then wouldn't it also be a moot argument that if you were to appoint a Christopher Townsend to the bench, he being a well-known, well-experienced defense lawyer, everybody gonna get wet?
No, I am also, my history is that I was also part of the prosecution arm. That is where I started my career. So perhaps a Chris Townsend would be a little bit more balanced, because we see things from both sides. We know what it is that is the trickery of, say, the police force, how it is that they do things, because we're on the outside, we're in the trenches looking in. Prosecution, they don't have that eye at all.
Now, implicit, Christopher, in what you said earlier, implicit is that there is no right to a jury trial.
No, there isn't any right to a jury trial. I think the Chief Justice made that clear, though he shared an opinion, but it is an opinion shared by me, that there is no right to a jury trial. And I think we said it earlier on. If there was such a right, then the gun court would not have existed in the fashion that it has, and several other entities, arms of the judicial would not have existed in the fashion that they have.
All right, let's explore your position a little more. Is there any country that has totally within the common law, don't even confine it to Commonwealth, within the common law jurisdiction, is there any country that has completely dispensed with jury trial?
I think India did.
I don't know why. I think I heard Singapore as well.
Sorry?
I think I heard Singapore has done so too.
Singapore has done so too. Yes, I've heard that too. But I know for a fact that India did.
What are the downsides of jury trials? What are the dangers? What are the shortcomings?
Of course, some say because the jurors are not astute, they come up with, in some instances, ridiculous decisions. They take longer to distill the facts. And of course, you are prone to retrial because you have, from time to time, jurors falling sick, the numbers dwindling. You have to go to a retrial because of that.
Go ahead. Finish your point.
Yeah, so there are quite a number of reasons, I suspect, why are downside to jury trials. Go ahead.
I raised this earlier, and I want to hear your comment on it.
Yeah.
How easily can jurors be corrupted?
I suppose it is easy for jurors to be corrupted because in some instances you are getting from the pool of jurors, you're getting persons who can be reached because their finances may not deter them from not being corrupted. But the truth
and in addition to that, they may not be people of character. I mean, that's not a qualification to get on the voters list.
That's what I'm saying, because if you're corruptible, then it calls into question your character.
Yeah.
And certainly I've seen instances where clients who I know to have conviction, I've seen them in the pool. I've seen people of unsound mind in the pool. So there is that. And of course, they don't have a badge to say, I am of unsound mind, or they don't have a badge to say, I am a convict. So there is that. From
your experience, you have done jury trials, haven't you?
I've done tons of them from both sides of the fence.
Tell me, from your experience, how attentive are jurors to the evidence that's being presented? The reason why I asked you that, I mentioned that I served on a jury in a coroner's inquest.
Yeah.
And to sit for 5 hours listening to evidence can be a little stressful, no?
Yeah,
I made sure to carry a little flask with some black coffee. Because I know I needed to keep my brain alert, no? But from your experience, have you seen jurors dozing off and so on?
Yeah, man. I mean, that's a daily occurrence. From time to time, you will doze off, and I dare say, from time to time, even judges doze off too. But
so everybody dozing except the person giving the evidence.
Now and again. and even defense counsel, from time to time, you'll see one or two those things are common. But the truth is, what happens is that is why you have numbers. So what it is that you miss, I will catch, and therefore it is really a collective effort in coming to what the truth is, or what they think the truth is.
How smart are the typical jurors in terms of, they're not trained in law, but in terms of applying good judgment, common sense, being perceptive when they're listening to the evidence, from your experience?
From my experience, and my friends who are judges out there might be a little bit upset. But I find them to be more understanding of what life is in Jamaica and on the ground than perhaps.
But what should that have to do with their consideration of guilt or innocence?
Because sometimes, they will know what the truth is. They know that what happens in society, what happens, for example, most of these sometimes offenses happens in the inner city communities, which they are from. Some of our judges, they don't appreciate exactly what happens there, the language that is used and the meaning of the language there, when it is that our jurors, our peers would. And that sometimes gives a different flavor. It adds something to what the truth is.
How do we avoid...
And form a totally different interpretation as it relates to something than what somebody else would.
How do you...
I give you an example. I did a case once where the firearm was described as blue steel, and the judge did not convict because, from her perspective, the firearm was made of regular steel. Not understanding that really and truly, and most people from inner city would know what a blue steel is. She didn't understand that blue steel is the description given to the material that makes the firearm. So you have those little idiosyncrasies. You even have the language where a judge wouldn't understand the language of the inner city when it is that the witnesses giving the evidence, and the jurors would. They know what it means.
What do you do in a situation where somebody is selected to serve as a juror on a case that involves carnal abuse, for example? And that person is somebody whose daughter was the subject of carnal abuse 20 years ago.
Yeah.
That may not be known to the defense lawyers, so they don't challenge that juror. But that juror comes in possibly with an inherent bias that all people who carnally abuse children, if they even suspected, then must go to prison. How do you avoid that?
Well, the judge does give a direction in the beginning and does ask the juror whether or not they have any reason, and they give an indication of what those reasons could be for serving. And so they're invited to declare their hand if it is that they are unable to come to an unbiased verdict.
If they are conflicted.
If they are conflicted, yes. Those are the safeguards that the ordinary or the learned judge who sits, those are the safeguards that he or she has to advise herself. That you have to eliminate bias from your decision making. Now, whether or not it happens, we don't know. But that position is true for both jury system and judge alone. A judge could have a relative who
yes.
The victim of carnal abuse.
Except though that one may argue that one would hope and expect that a judge would have greater control over their own biases than an ordinary juror, no?
One could argue that. They're human beings. And my experience is that the bias is brought to the table or the bench. I have seen it.
Yes. Let me ask you another question.
There's a tale there's a story that is actually being told long before or when I was a young lawyer about a judge who did not convict a rapist because from her perspective, sex could not happen from behind, and the man walked free.
Oh.
So you do have those biases, and that bringing their experiences or lack of experiences to the table, no matter how it was explained to her.
Tell me, what happens in a case where a jury returns a verdict that the judge considers to be egregiously wrong?
In quite a number of instances, the judge reprimand, but have to accept.
Can the judge send it? Can the judge send the jury back for reconsideration?
If he disagrees, if he or she disagrees, no. They'll be trespassing upon the role of the jury, and the determination of the fact is solely theirs.
But have you seen situations where a jury comes back with a verdict that is just incomprehensible?
Yes.
But wouldn't
both sides? I've seen instances where judge alone comes back with something absolutely ridiculous and totally outside the law.
And then you have to take it on appeal.
You take it on appeal, yes. Well,
so what you're saying...
It's not in your favor. In some instances, you're doing a case. I mean, I've done cases where judge rule in my favor, but I appreciate that it is totally outside the law. And there's the reason for the decision is non-existent, meaning that those were not the facts, and you wonder what case they were listening to.
But that is an awful indictment of the bench.
It is. Remember, the bench is not perfect,
Well, none of us is.
It's not a perfect system. And it is flawed.
But you argue that what you're basically saying is that neither jurors nor judges, neither is perfect.
Neither is perfect.
But you would be you would be prepared to support the Chief Justice's position that we should just stop the inching and just deal with it once and for all and deal with bench trials.
Yes, I believe that if we get there, then we'll be able to commence fixing the system. Meaning that since we're getting there, let us get there and then fix it. Now, there are a lot of things that's wrong. As I mentioned earlier on, the recruitment process, I believe, needs a little adjustment.
But is it that people from the private bar, like yourself, have no desire to serve on the bench?
I can't pronounce upon what my colleagues would want or not want, but for me, I believe that my role is really in the trenches as defense counsel, and from time to time prosecuting counsel, because I do take a brief that will take me into the realms of prosecution from time to time.
Positions that are open for judges are advertised, are they?
Yes, they are advertised, I believe, yes.
Do you know what the response normally is? What that experience has been?
No, I'm not aware. I'm unaware of what the responses are like. But I do know that now they're drawing from different areas, and like different ministries, etc. And there are persons who, from the private bar, that have applied. So the system is changing, or the recruitment process is changing, but we won't be feeling the effects of that change in our generation.
Do we have sufficient judges, or we're short?
My recollection is that we do have sufficient. Well, when you say sufficient judges, I think we have the allotted amount. I do think that we need more. Or certainly what we need is that we need more judges doing more work.
And we probably need more facilities for cases
and
to be
need more
held.
facilities, etc. Right? And then again, one can make the argument too that what we have, we're not using it in the best way that we can. Somebody made the point recently that when you go to the Supreme Court by 12 o'clock, all the courtrooms are empty, but yet still you can't get judgment.
No.
So the question is, what then? Where's the time being spent? But I won't go there.
I had a look at some numbers some time ago, not recently. So I don't know how current these numbers are. But when I looked at those numbers, we had something like, don't hold me to the figure, but my recollection is that we had something like over 300,000 cases being filed in our courts each year.
Mm-hmm.
We had a hell of a backlog of about a little more than that. But each year in terms of new cases. Now, albeit a good portion of that had to do with traffic offences, which are still offences, so we can't simply brush them aside.
No, we can't.
But for a country our size, I mean, even if we had the most efficient court in the world, we would wear it down. Why do we have so many cases being filed in a country with less than 3 million people? Is it that we're so lawless?
Is it the amount of cases that are being filed or the amount of cases pending?
Well, I looked at two figures. I looked at the number of cases that were carried over from the previous year.
Right.
And then I looked at the number of cases that were filed for the year being reported. I got it from the Economic and Social Survey report.
Mm-hmm.
And it, as I said, don't hold me to the figures because I don't have it in front of me.
Right.
But I said to myself, I mean, some of them, of course, would be cases initiated by private citizens, no?
Right.
So I just said to myself, is it that we love courthouse, or is it that we break laws so much that we have so many cases? No wonder we have a backlog. No court system couldn't handle that kind of load.
No, but there are several contributors to that. One of which is my pet peeve, is this constant adjournment of matters. Is really our disposal rate that I have a problem with. And so when it is that we make stupid decisions in court and we carry over matter, I like to call it carting the matter to the next person, to the next panel to make decisions, and they don't make decisions. Then what happens is that you create a backlog, and we're seeing what we're seeing now. So some of these cases that are coming forward are cases that have been in the system for some time.
But I've heard people argue that nobody asks for adjournments as much as lawyers, defense lawyers. Is that true?
No, as a matter of fact, the study is that the prosecution asks for far more adjournment than anybody else.
What are you saying to me? I thought it was the other way around.
No, man, it's the study showing all the words. I mean, every time I go to court, even if I want an adjournment, I don't need to ask for one because I can count on the prosecution not being ready. So all I do there is just sit down and shut up and make them ask for their adjournment.
I follow you. Chris, I'm enjoying the discussion, but unfortunately I'm out of time.
Oh, my.
I want to thank you so much for joining me today. We're going to continue the discussion after the break, but thank you so much for your input.
All right, not a problem. Thank you. Bye-bye.
We take the break. Welcome back. It's Jamaica Live. We're on Bridge 99, broadcasting from Kingston. We're going to be linking with Our Jam in New York shortly. I got a chance to hail up Beauregard and his crew. We're talking about the recent call by the Chief Justice, Mr. Brian Sykes, for the abolition of jury trials. And a point that Christopher Townsend made before we took the break is that we have been inching there, that there have been sort of creeping pieces of legislation that excludes trial by jury. Legislation having to do with criminal offenses. So that it's not a brand new idea. Apparently we've been going there, and what Mr. Townsend was suggesting is that the Chief Justice was saying, well, make a decision and go there. We want to hear the views of someone who has expressed himself publicly on the matter. Another noted attorney, Mr. Delford Morgan, who is a member of the Cornwall Bar. Mr. Morgan? Do we have him on the line? No, we don't have him on the line yet. Anxious to get his view. Mr. Townsend was quite supportive of abolishing trial by jury and having cases tried just by a judge or a panel of judges. And he gave his reasons, some of which I hadn't really appreciated before. But I'd love to get. We're hoping to link up with Mr. Delford Morgan, because he wrote a piece in response to the Chief Justice in which he argues very strongly, strenuously, that jury trials should be retained, that they are an important part of the justice system. Have we linked with New York yet? Beauregard, are you there? Hello, New York, Beauregard. Not there yet, no. It's been so cold up there. I think the temperature I looked at this morning up in New York is 20 degrees. If you have 20-degree temperature, I wouldn't be surprised if Beauregard is still under the blankets. But no, we're going to talk to him in a little while. Mr. Delford Morgan. We're having a technical challenge in terms of getting him on.
I'm hearing you loud and clear.
Hi, Mr. Morgan. How are you?
I'm good, sir. How are you doing?
I'm fine. How is the Cornwall Bar?
Still being relevant.
Yes.
Still doing no work.
The Chief Justice has said we must cut the foolishness and just cut out jury trials altogether. And you disagree. Why do you disagree with that? The eminent Chief Justice.
Because jury service is such an integral part of our democracy. It's an integral part of our constitutional arrangement that to dispose of it.
Pin that down for me, because I looked at the Constitution. I can't find it anywhere in there.
Well, you would not find it in the Constitution. You would not find it enmeshed in the Constitution. But you know very well that there are issues that have constitutional bearing or moorings, but don't get specific mention in the Constitution. I cited a case in the article I wrote, which dealt with the challenge that to serve as a juror because I don't want to judge anybody. The court said no, because of the importance of the jury system to trials, it touches and impinges on the whole issue of law and order and public order.
What is the inherent value of jury trial, and how does that provide a better quality of justice or a better outcome than a judge alone trial?
There can be no better way to ensure fairness than to have cases tried by serious criminal cases tried by our peers.
Why you say that?
Because it is as simple as this. When charges are brought against a citizen of this country.
Hello? So I thought I'd lost you. So, yeah, go ahead.
When serious charges are brought against citizens of this country, one of the safeguards for fairness is not necessarily to have a judge of the Supreme Court try the case, Because judges do not and are not as exposed to what happens in our communities and on our streets as much as those who live on the streets, those who interact in the streets. This has been for almost 1,000 years in development of the common law. Even in the United States of America, there are very few things more fundamental for American jurists than the jury system. It is not the system itself that is wrong, sir. What is wrong is that for some reason we have contrived only to use as jurors those persons who find it more difficult to do so. In other words, even though we take the jury or jurors come from the voters list, we never find the professionals who successful business persons and professionals. We never find them being summoned for jurors.
Is it that they're not summoned, or is it that they find a way to escape it? I don't know. I mean,
no evidence that they've been summoned.
Well, I was summoned for a jury, and I'm sure that whoever was summoning me recognized my name, but that didn't stop them from summoning me. Well, and I went and served.
Well, you went and served. How many persons in your standing? How many persons are far less standing than you?
Yeah. Well, but that's the question I'm asking, because I mean, one of my lawyers said to me, look, I can go to the court and get them to excuse you. And I said, no. I mean, I believe I should set an example, so I'm going to go. Now, I don't know to what extent chief executives and professionals, I know doctors are exempted, but I don't know to what extent an architect or an engineer is being called to serve. And he finds all sorts of clever ways. He has a lawyer like mine who will go to the court and say, no, look, he's busy on a matter and he may have to travel. I'm not busy on nothing. I'm not traveling nowhere, but him just don't want to serve. I mean, the jury that I sat on were ordinary people, and they were good jurors. Let me just say that. They were really good. I was very impressed with them. But one of the questions that I perhaps forgot to ask them is, how many juries have they sat on before? This was my first time.
Yes.
But I don't know to what extent the court administrators are finding that they have to be calling the same people over and over again because the others are finding all sorts of clever ways to escape.
It is not my experience that people are exposed to repeat service. It's not my experience. But the other issue though is, do trial judges dispose of cases easier, more expeditiously? I don't think so. If you look at the backlog in the gun court, where jurors don't sit, it's the same problem.
Are jurors corruptible?
I would
imagine. I pose a hypothetical situation.
Yes.
You have a juror sitting on a case.
I've not in almost 3 decades of criminal practice seen one single instance.
But you wouldn't see it.
Or heard of one single instance. I heard about the one with Vice Cartel, whatever transpired, it did not fit the verdict.
But Mr. Morgan, I mean, we have such a troubling level of corruption in Jamaica. You can never have a briber unless you have a bribee.
Mm-hmm.
Now, I threw out the hypothetical situation. I'm a Don man, right?
Mm-hmm.
I am facing a serious charge, a murder charge, 7 murder charge. My Don man business has amassed an enormous amount of wealth for me. I have a jury of 12. I only need one to stick out. If I find a juror and I try to pick the one who look like him could have well do with some money and put $500,000 in a brown paper envelope and send it in a brown paper bag and send it to him, what is the likelihood that some, and I would never say all, what is the likelihood that you're going to end up with a situation in some cases where one person stick out so the person can't be found guilty?
Yes, hypothetically, that is not unimaginable. But, we don't have experience of that kind to form the view that this is something we need to guard against by getting rid of the system.
Do you know of any case where somebody may have been charged for attempting to bribe a juror?
Yes.
So a situation like that have actually been brought to the court and the person has been punished, no?
It has been brought before the court, yes.
I see. Not many cases, though.
Very, very rare. Very rare. Very rare. But I think the jury service has been of such long-standing value to our community that it is not without serious concern that I take the stance I take. We just can't go about abolishing things that can work if resourced properly. We just don't go about doing that. I don't see how we are going to improve. Well, the court administration agency said that jurors on a whole return more guilty verdicts than trial judges alone.
From your experience,
yes,
do you find jurors to be attentive, to be? I mean, you can look at a juror's face and body language to determine whether or not that person is daydreaming or whether they're really paying attention to the evidence. What's your experience? From you spend a lot of time at the private bar.
My view, they're always paying attention. What you get across is you get a sense of whether they are with you or against you during the trial. Your body language will tell you whether you are the crowd
and their eyebrow language.
And their eyebrow language.
Yes. Now, when I served as a juror, that was back in 2016.
Yeah.
The allowance that government paid was $2,000 per sitting. And that had recently been increased. Was increased in 2015. Before that, it was $500.
Yeah.
But good God. How you expect an electrician to give up his work because his kind of work, it can't be done while he's serving on the jury. If he's not there, the work can't be done. Why we can't do better than that? I made the point that if you're appointed to a government board and you attend a board meeting and pay you $10,000, $15,000.
Yes.
So why we can't do something sensible with the jurors?
That's the point I'm making. That's the point I'm saying. The system can be ameliorated greatly by just a little bit more stipend being paid, covering the transportation, the cost for the transportation, public or otherwise, and you don't even get money to buy lunch.
Well, in my case, they provided lunch. I don't know what is done normally, but certainly in the case that I sat.
It is provided not from a budget, but I can tell you that across the island, the courts uses their, they're able to provide a little water or a sandwich or lunch sometimes. Not all the while.
Mr. Townsend made the point, and he wasn't talking with water in his mouth. He said that most of the judges, it's changing now, he says, but he says most of the judges have traditionally come from the government's prosecutorial arm. And therefore there is almost an inevitable bias that they bring to the bench. Do you share that view?
Well, yes, that is clear-cut. That has never been disputed. That is a fact of life.
What other concerns you have about a judge having known a verdict? Why would you be uncomfortable with a judge having listened to the evidence and they take these copious notes that prolong the trial for so long? So they have all the facts there. They will take their time to go back through the notes and so on, and then they will come and hand down their verdict. Why are you uncomfortable about that? One, and two, I'm sure that in your time you have seen verdicts that you consider to be good and bad coming from both the bench and the jury. Which one is more predominant?
I must be honest with you that I have a bias for jury service, because living in a community, being more au fait with the mores and the dealings and, meaning given to slangs and words used, a jury invariably is in a better position to arrive at a true verdict than a trial judge in a typical.
But because that decision is influenced by their understanding of the norms and values in the community. Isn't it possible that is exactly what you want to keep out of the consideration?
No. You don't want to leave that out. You don't want to leave that out.
Develop on that for me.
Because when a witness, for instance, says an accused man makes a comment to a juror, that comment may have a different meaning than to a trial judge, who, by virtue of her standing, by virtue of her position in society, he or she is not normally found where that kind of language is spoken, where that kind of activity happens. And therefore, to exclude those with those peculiar knowledge of meaning to be given to things.
But is it not also possible that a juror who understands the runnings in a community, understand the behavior? You have somebody who is before the court charged with rape. Isn't it possible that a juror may say, well, but the girl, she go and dance all the while, so she must expect something like that can go on.
No, because I don't think so. Because he or she has sisters, daughters. He herself might go to dance too. And they clearly is a demark line, If it comes to rape and them kind of things, there's a clear line that they know where the line is to be drawn. And that line is very well in accordance with the law.
Can I beg you just hold for me? I have to take a break, but it won't be long. Let me come back to you. It's Jamaica Live. We're on Bridge 99, and I believe that we're with New York now. Beauregard.
Good afternoon, Mr. Golden.
Hey, what I'm Chief. I'm looking for you. I can't find you.
I'm right here. I didn't go anywhere.
Tell me something now. 20 degrees Fahrenheit last night? Was that what the temperature is up there?
Yes, some freezing rain last night. Actually, over the weekend we had some freezing rain, but it's raining also today, and it's a little bit warmer, 37 degrees.
So how you cope?
Well, we just dress warm, dress comfortable. Make sure we dress for the occasion. Wear a jacket, wear your hats, wear whatever you need to put on to make sure you feel comfortable going out there.
And you don't walk with a flask of white rum?
No, I don't walk with it.
If it was me, it wouldn't be a flask, it would be a whole quart bottle. Well, I hope everybody up there is keeping themselves warm. And
everybody is actually good. Yesterday was Bob Marley's birthday,
yes,
so most people were celebrating that, and I took most of my time to actually watch the 77th Earth Strong celebration on YouTube that they put on for Bob Marley. And I must say, big ups to our in studio producer there, Mr. Moy Campbell, who actually saw on the production as well.
Good, good.
Yeah,
and of
Miss
course, I
Kingston.
think Dennis Brown's birthday was a week and a half ago, no?
Yes, last week.
Yeah. All right, good to hear you. Stay warm.
I will.
Good. We're talking about jury trials today, whether or not we should do away with them, as the Chief Justice has suggested. And we've been talking to Mr. Delford Morgan, a well-known attorney from the Republic, from the West, member of the Cornwall Bar. Mr. Morgan,
Yes.
Are there any circumstances in which a judge can dismiss a jury?
Sure.
What would be those circumstances?
If it comes to the attention of a jury that
Of the judge?
of the judge, sorry, that anything has been done or said that could potentially compromise the whether a particular juror or more than one, or the entire panel for that matter.
Mm-hmm.
Then the judge has a duty and the right to dismiss that panel and to impanel a new one.
And then the trial would have to start all over again.
Yes.
Now, what does a judge do if a jury comes back with a decision? Because jurors are fact finders, no?
Yes.
What if a jury comes back with a decision that the judge feels ignores, completely disregards facts that were clearly established during the trial, not just by testimony, but even possibly by forensic evidence? What does a judge do? I mean, a judge can make comments. I'm told that a judge can say, this is a preposterous verdict that you have arrived at. But is that the limit of his?
It is, because there are two important considerations here. Firstly, the jury's decision is final on facts. But more importantly, there's no witness. And I made that point because you mentioned forensics. There's no witness whose evidence a jury is obliged to accept.
Even forensic evidence?
Even forensic evidence.
Oh.
So even an expert witness, the jury has the right to reject.
So if my DNA is found on the gun, the jury can ignore that? Theoretically?
Yes, the jury can.
I see.
The jury can.
Now,
the judge could too. What if the judge were to find as a fact or to entertain a doubt as to how it got there?
Yeah. The difficulty that some people like me have, is that you don't expect a judge to demonstrate that kind of frailty. But I'm not sure that I can say that for everybody on the voters list who might be selected as a juror.
Well, I quite agree with you on that. You and I would not want to be heard saying that, even though theoretically it is possible.
Yeah, theoretically, yes.
Yes, it is possible.
And I've seen situations, not in Jamaica, but in other jurisdictions, where judges have been indicted by grand juries for accepting brown paper bags.
Of course.
I haven't seen it in Jamaica, but and thank God for that.
Well, we have had one situation in Jamaica.
Yes, you're right. I remember. Yes.
Yeah,
Now that you mention it. Now that you mention it, yes, there was one. Yes. Yeah. About 10 years ago, or a little more than that, maybe.
Yeah, a little more than that. About 15.
Yeah. Yes. Were you practicing when the Good Court was established, or you were a youngster?
I was a youngster then.
Because what was the position of the defense bar when the gun court was established and those cases were insulated from jury trials?
Well, if you recall, the landmark case of Hines versus the Queen, that came out of the out of the whole the whole attempt to create this new jurisdiction.
Yeah, but it wasn't on a specific issue of trial by jury, though.
It wasn't. Well, it was on the issue of creating courts.
No, but I think my recollection is that it was the issue of sentencing. Was this indefinite something or the other?
That was part of it, but the establishment of the gun court itself was a
but that was administrative. They had to tuck it back in under the Supreme Court, no?
Yes. And the decision, around that. But the same problems that plague the regular circuit courts are in fact the same problems that plague the gun court too.
Yes.
There's a lack of funding, a lack of resources, a paucity of incriminating material against a lot of accused persons. Sometimes when a man walks out of it, it's simply because it is not so much that the police may have fingered the wrong person in as much as they have failed to provide sufficient evidence to connect him to what they allege. So whether you remove jurors or not, you're still going to have that hurdle to cross. Quality
of investigations and preparation of the case.
Yes, but ultimately affect the quality of the allegations coming up for hearing or trial.
Well, why would India and Singapore and there are a couple of other countries within the common law jurisdiction, within the Commonwealth family as well, why would they be so bright or so foolish as to do away with jury trials?
Well, Singapore perhaps is on a limb of its own. It's not a thriving democracy as we are. And for India, I perhaps could point finger at what I would call the racial mix of India.
Yeah, but I don't know that you're making a link there, are you?
It's the only reason I can point to as to why a country like India would do away with the jury system.
What's the future of the jury system in common law jurisdiction? Is it that we're going to, because what Mr. Justice Sykes said and Mr. Townsend pointed out as well, is that we've been moving towards it, but we're moving it in little piecemeal ways. What's the future of the jury system in Commonwealth jurisdictions and in common law jurisdictions like ours? Is it basically on slow death? Is it something that's likely to increasingly disappear over time?
Yes, clearly. I think the system is being starved, it's being suffocated, everything is being done to bring it to a point where we all throw our hands in the air and say, okay.
No, you're not serious about that.
I'm serious.
Serious. It may very well be a casualty, but I don't know that it is a design.
I believe it's a design. I believe it's designed. I believe so, Mr. Golo.
Well, I'm trying to recall, during the time that I was in office, I cannot recall the issue ever having come up, so it wasn't something that had exercised my mind in any way at that time.
It started around about 2014, then the thinking about that we need to reform the jury thing, we need to reduce the number of jurors, reduce the number. Among that reduced number, you have a majority. You can take a majority verdict of guilty.
Yes, that's when they reduced to 7, no?
Yes, and 5.
Yeah, but the part of the problem we were trying to address at that time was the number of instances in which you couldn't get a unanimous verdict, and therefore you were left with almost a not guilty decision by default. Whereas I remember the argument, although I wasn't sitting at the desk at the time, but I remember the argument The argument was that if you have a super majority, a substantial majority of the jurors, that should not prevent a decision from being made. There's nothing wrong with that.
There's nothing wrong with that. There's nothing wrong with that.
Because in the case of a jury of 12, it has to be a minimum of 9, no?
Yes.
And in the case of a jury of 7, I think the minimum has to be 5.
5.
Have you seen decisions coming back sort of 9-3 and 5-2? Or are most of the decisions where unanimity is not a requirement? Are most of the decisions still unanimous from your experience?
Still unanimous. A hung jury is perhaps, I would have, from my experience, I would think 1 in 50 cases you'll get a hung jury.
Well, a hung jury is different from a qualified majority, no?
Yes, it is.
A hung jury is when you can't even meet the threshold of the qualified majority.
Yes.
Yes.
Yeah. But as you say, it seems to be on slow burner because I think it clearly has to do with costing, as the Chief Justice said. It's a question of costing. But
costing?
Costing. The cost for having jurors.
$2,000 a day?
Well, if you multiply that for all the jurors turning out, because people will turn out. People turn out.
Well, I would hope.
Why we have the situation where we can't have jury trials, Mr. Bowling?
Well, I'd hope that I would hope that the decision would be informed by what is considered to be the best way of dispensing quality justice. It can't be that. It can't be that we can't find the $2,000 to pay so many jurors. Because in my view, it should be much more than the $2,000.
Well, we can't even. There's no.
But we can. But we need to improve the administration as well. Because I remember on the jury that I sat, we met 17 times, but it wasn't all 17 times we were hearing evidence.
Yes.
On some days when we turn up, the case can't proceed because of some administrative problems, but we still have to be paid because we turned up, no?
Yes. Yes.
Well, the discussion is going to continue. I really... do you know whether or not the Bar Association, there's a Cornwall Bar Association of which I think you were the president or maybe still are, no?
No.
But are the professional bodies that represent the legal profession, are they taking up this matter? Are they responding? I saw your letter in the press.
Yes.
But I haven't heard anything from the Bar Association of Jamaica or from your bar, your association.
I haven't heard anything of it either.
Is there still an Advocates Association?
There is an Advocates Association.
But deafening silence. I'm surprised. I thought this was an issue that would have...
It is worrying, I should say. It is worrying that an important issue like this, and there has been no comment from the Bar Association.
Maybe a detailed response is being prepared.
I hope so.
Mr. Morgan, thank you very much for joining me today, and thank you for adding your views and your considered experience to the discussion.
Thank you.
We take a break. We've been discussing today the question as to whether or not Jamaica should do away with trial by jury. And as came out in the discussion, there's no constitutional entitlement to trial by jury. In fact, Parliament has passed legislation dealing with certain classes of offences and made it clear that these are offences that would be tried by a judge or by a panel of judges. Although Mr. Delford Morgan did point out that sometimes something is not specifically set out in the Constitution, but in the general scheme of things in the Constitution, sometimes there are implicit constitutional entitlements, no? As to whether or not that applies in this case, I'm in no position. I'm not qualified to determine. But today we're following up on a call that was made by Mr. Justice Brian Sykes, the Chief Justice of Jamaica, who took the view, and he was quite strident and plain spoken in his comments, where he said that we should get rid of jury trials. And he pointed out that we've been inching there, but we really ought to just... He doesn't feel that they provide any assurance of better outcomes in terms of the quality of justice. On the contrary, he feels that they create hurdles for the justice system, getting jurors assembled, getting jurors to sit. And there have been cases that I know who just can't get going because they have problems in empaneling jurors. Mr. Townsend, with whom we spoke, who is an attorney at law, he's supportive of the Chief Justice's position, although he made the point that some of the weaknesses in the jury system also exist at the bench level. So it's not that judges do not have their own limitations and do not have their own possibility of lapses. We're talking about things like prejudice. And he made the point that judges have in the past come predominantly from the Office of the Director of Public Prosecution. So they come with a sort of prosecutorial experience, no? And their sort of training and orientation is to lay down the evidence to secure a conviction. Now, when you leave that kind of disposition and you go sit on the bench, some of them may have a difficulty in divorcing themselves from that kind of experience or that kind of practice, to understand that, look, you have to listen to the evidence, but if the evidence is not convincing, then you ought not to convict. I still have some concerns about how to ensure that we protect ourselves against corrupting jurors. I worry about it, because the principle of a jury is that they're not supposed to be, they're not supposed to be bishops alone or men of high standing alone, because even some men of high standing can be corrupted. They're ordinary people. But I just worry about a juror who, having problem paying the rent, hasn't paid the mortgage for 6 months and they're out to foreclose on the house. I'm just worried when somebody turn up one day and said to him, listen, no, we can fix you up, but you have to deal with this case. Now, I don't know that it happens. I'm just more than a little concerned at the possibility that it can happen. Not to say that it can happen with a judge as well, because as I mentioned earlier, I've seen cases, not here in Jamaica. Well, yes, there was one case in Jamaica. But I've seen a number of instances in America and in other jurisdictions where judges have been charged and some of them have been sent to prison because they were corrupted and they took money to fix a case. But I think it's much harder to do that with a judge than it is to do with a jury. And an ordinary juror who may be in a position that makes him more vulnerable. That has been the discussion today. We really, it's something we need to focus on. I'm surprised that there has not been a reaction from the associations that represent the private bar, the bar associations, and we have at least two. We have Bar Association of Jamaica, and we have the Cornwall Bar Association. I believe there's one in Mid-Island too, I'm not sure. There's the Advocates Association. I'm surprised that they have been so silent on it, and maybe we're concerning ourselves with an issue that already some level of consensus may have emerged among the critical practitioners in our court system, that either this is the way to go or this is a way that we will inevitably go, where there has been such silence on the matter. But I hope it's something that you will give some serious consideration to, because it could affect any one of us. Any one of us could be charged and put before the court. And we may be perfectly innocent, but we can be charged. And our innocence may be what a jury is going to have to consider. And we will have the choice, of course, of saying, well, we don't want to be tried by a jury. We prefer to be tried by a judge. So it is something that all of us need to think about. If we were to find ourselves in that situation, which one would we feel more comfortable with? Having our fate determined by a judge or a panel of judges, or having our fate determined by people like us, who perhaps understand the kind of situation that we might have been in and would be prepared to understand that it's not something that we did, sort of knowingly, willingly, and therefore it's not something that we ought to be punished for. So it's something that I think you really should start giving some thought to and come to your own opinion. That is Jamaica Live for today. We hope to join you again next week to take another topic, take on board, to dive into it, to delve into it, to look at the issues from all angles, and hope that in doing so we're going to be able to provide you with material that you can use to form your own opinion on issues that affect us and affect our country in profound ways. God bless you. See you next week.